Out in San Diego, we have Dod Ghassemkhani, who is a criminal defense attorney outside of the courthouse, kind enough to speak with us on this Friday while the jury is out, but court's in session. Dod, thank you so much for being with us. And if you were just listening to what we're talking with, I'm talking with my guest in the studio, Mark Begnaud, about a possible football analogy for reasonable doubt. In this case, in closing arguments, your thoughts on how that might resonate with this San Diego jury?
Well, thanks for having me on, Julie. That's a great question. In any jury trial, in my closing argument, I do a long explanation of what is proof beyond a reasonable doubt. And usually what I explain to the jury is proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charges are true. And then I break it down. Well, what does abiding mean? Abiding means to long live your decision. And I even break it down even further, and I let the jury know that 5 days from now, 10 days from now, a year from now, if you look back on this case and you go through all the testimony of the witnesses and you analyze it, if you have any questions 5, 10 days, 2 years, 3 years from now, then the answer is reasonable doubt, and you must acquit the defendant. I also use charts, and part of those charts are, even if you go back there and you deliberate and you believe Mr. Winslow may be guilty, that he is probably guilty, he could be guilty, I have a strong suspicion that he's guilty, that even if you think any of those things, then under the law of California, you must find him not guilty. And the reason is you don't have an abiding conviction that these charges are true.
Sure. Now, appreciate all of that, Dod. Great information to put before a jury. Sure, that explanation resonates well. I want to ask you, too, about something in California. You're obviously very well versed in California law, in your criminal defense practice, and in different jurisdictions, call it a different name, could be a motion for judgment of acquittal or maybe motion for a directed verdict. But we understand that may be what's happening too today. The defense going to make that motion. Talk to about what it's called in California, and if you think there's any possibility the defense could prevail here.
Well, to get to that last question, is there any possibility that the defense will prevail? And the answer to that is absolutely not. We heard the defense wanting to bring the motion yesterday after the prosecution's close of the evidence, and the judge said, just bring in your witnesses, we'll make the motion later. So right there, we know that Judge Bowman is not going to grant the motion. Now, under California law, under Penal Code Section 1118.1, what the defense will argue is based on the evidence that was presented, based on the witnesses that we heard, and based on everything that we heard on the witness stand, there is insufficient evidence for a reasonable jury to decide guilt or innocence. And at that point, Judge Bowman is going to decide whether or not there has been substantial evidence presented for this jury to decide. And the answer to that is yes, it's a he said, she said case. With Jane Doe 1, Jane Doe 2, Jane Doe 3s, 4, and 5, it's a he said, she said case. So there is substantial evidence, and there is sufficient evidence for this case to go to the jury and make a determination. So the answer, will the 1118.1 be granted? It's going to be denied.
And the 1118.1 in your statute, is it called motion for acquittal in California?
Correct.
Correct. Very good. Dod, appreciate that. Curious, in your practice, have you ever had any cases before Judge Bowman?
I haven't had any jury trials in front of Judge Bowman, but I've had several preliminary hearings in front of Judge Bowman. I know Judge Bowman. He's a fantastic judge. He's very cautious. He was a former prosecutor, and he was a great trial attorney when he was a prosecutor, and he has a great reputation as a judge here in San Diego.
How about the attorneys? Have you ever had any cases with any of the attorneys, Deputy District Attorney Dan Owens or anyone on the defense side?
Well, starting with Dan Owens, yes, Dan Owens has been a prosecutor his entire 10 years. He's on the sex crimes unit. I've had several cases with Dan over the past 10 years. As far as the 3 defense attorneys on the case, all 3 of them, they're good friends of mine. Emily Barr, she's a good friend of mine. I know her husband. She's married to a public defender here in San Diego County. Brian Watkins, we currently have a co-defendant case together. And Mark Carlos, him and I have been friends for a pretty long time. Mark has been practicing in this county for significant amount of years, and he's done several hundreds of jury trials. And Mr. Winslow is in good hands with these 3 attorneys.
Sure. And is it a close-knit community in the courthouse? I mean, prosecutors, defense attorneys knowing each other, getting along well. What can you tell us about the community there?
It's an extremely close-knit community. Here in San Diego County, we have 4 different courthouses, and it's a pretty small defense bar, and there's not too many district attorneys in San Diego County. So everybody here in San Diego County, the defense bar, the DA's office, everyone knows each other.
Okay, and Dod, I want to ask you one question before we have to go to break. Tell me about the juries. Typically, what kind of juries do you see there in San Diego County?
Well, it depends on the courthouse, and here in Vista, we have a very conservative jury pool. If this case was somewhere else in San Diego County, it might not be the same, but here in Vista, of all 4 courthouses that we have the most conservative jury pool.
Okay, good to know. All right, Dod Ghassemkhani, criminal defense attorney, joining us live from San Diego outside of the courthouse. Thank you so much for sharing your expertise with us. We certainly appreciate it. Right now, we have to take a quick break here on Court TV Live. We've got our cameras in the courtroom for you. Following this case, we're waiting for the court reporter to arrive, we believe, in order for the attorneys to argue before the judge what they want to see in the jury instructions in the case of the state of California versus Kellen Winslow II. Don't go away. We're back after this.